Hi, this is the second lecture for the topic on civil rights, and in this video we're going to be taking a look at the struggle for civil rights. There is a lot of information in the textbook that you'll be reading, and so the goal of this lecture is to provide you a quick overview of the major civil rights movements, court decisions, and legislations that have defined civil rights in the United States. Okay, so remember from our last chapter when we were learning about civil liberties. And remember, civil liberties are the what government must not do. Remember, we talked about civil liberties as the thou shall nots, telling government what they are forbidden from doing. Civil rights are what governments must do to guarantee equal citizenship and protect citizens from discrimination. In other words, it's taking positive action. It's a demand that we place on government. And that's why it says up there that civil rights are positives. And because they're positives, it moves us in the direction of forming a more perfect union. We're demanding government to tell us what the rights of citizens are and protecting the rights of citizens. And so civil rights is about defining who can participate in the political process and in civil society, who can vote, who can run for office, who can serve on a jury. Civil rights is also about defining how people are treated in employment, education, housing, marriage, and other aspects of American life. So when you think about democracy, rule of the people, who's considered a citizen is fundamental to a democracy. If we're saying it's government of, for, and by the people, well, who are the people and who are granted the civil liberties and the civil rights of participating in this democracy? The founding documents are silent on the subject of who counts as a citizen. There's nothing in the Constitution or the Bill of Rights that, or the Declaration of Independence, that tells us what are the criteria that you have to meet to become a citizen. And so we know that from our readings so far this semester that who's included in full citizenship is really a product of politics. Initially, African Americans were not considered citizens. Native Americans were not considered citizens. People who immigrated to the United States were not considered citizens. Okay? And so civil rights is about defining who citizens are and the guarantees that citizens get from their government. So civil rights are what government must do to guarantee equal citizenship and protection from discrimination. And as we're going to see in a moment, it's a product of social and political struggle. So on the next slides, I've kind of organized these to take a look at the general movement of the civil rights struggles and the corresponding court actions and legislation that have corresponded with the different eras for the struggle of civil rights in the United States. This first slide gives you images of the struggle for civil rights in the 19th and early 20th century. So on the bottom right-hand side is a drawing of an early abolitionist. His name was Wendell Phillips, and he's speaking against the Fugitive Slave Act of 1850 in an anti-slavery meeting in Boston. And we really see that, and I mentioned this earlier, and we see this in some of our earlier readings this semester, that the abolitionist movement is the movement that was fighting to end slavery, that they're from the founding, even in the colonial struggle, that there was a strong abolitionist movement that only grows stronger as we move towards the Civil War in the 1860s. And then there are two other images there as well. Up in this, the upper right-hand corner is a picture of Harriet Tubman. And as you know, Harriet Tubman was responsible for the Underground Railroad that led people who were slaves in the South to freedom in the northern parts of the United States. And Harriet Tubman was herself an escaped slave, a freed slave. But Harriet Tubman was also a strong suffragist. In other words, that she was an individual who fought for the women's vote. And there was a very large intersection between these two social movements, the fight to end slavery and the fight to guarantee women the right to vote. And Harriet Tubman is a good example of that. And on the left-hand side is a picture from the 1912s, so early into the 20th century, where you see some suffragettes in New York City and Greenwich Village in New York City who are holding a sign. They've come to the city to protest. They're from the West. And as you know, the Western states allowed women to vote much earlier than some of the Eastern states. And they're holding a sign that says, "We were voters out West, where don't deny us our rights in the East." And so I show these pictures because we have to remember that the struggle for rights is about political struggle and taking direct action, whether that's protesting, as the suffragettes did, or holding group meetings to spread the word about the evils of slavery, or to take the direct action of actually freeing slaves, as Harriet Tubman did. The fight for civil rights is about real people and real struggles and how those struggles play themselves out in law and court decisions. So what were some of the key legal legislation and key court decisions that correspond with the civil rights struggles from the 19th and early 20th century? Well, following the Civil War, there is obviously a fight for racial equality. I mean, the Civil War is a war that is, settles the question about the role of slavery in the United States. And the Union wins and defeats the Confederacy, who was defending the institution of slavery. And following the Civil War, there were some changes that were made to guarantee equal treatment under the law. And we've talked about this earlier, but following the Civil War, the 13th, 14th, and 15th Amendments are added to our Constitution. The 13th Amendment ends slavery. The 14th Amendment, as we know, provides equal protection of the law. And the 15th Amendment, as well as citizenship rights for former slaves. And also the 15th Amendment says that you can't discriminate based on race when it comes to voting. And so obviously those additions to our Constitution are hugely important as it relates to determining and assuring equal treatment under the law. Another aspect of the post-Civil War and the struggle for racial equality was the efforts to reconstruct the South. And so as the South and the Confederate States rejoin the Union, the federal government goes to the South, and there's basically federal oversight of the way that the South treats the African Americans who live in the states. And so there was a very strong, federal oversight to ensure that African Americans were not being discriminated in the South. But that's a very short-term project. You'll read in your textbook about the election of Rutherford B. Hayes and the compromise that gives him the presidency and results in the end of Reconstruction in 1877. And so Reconstruction fails, and it brings about the institution that's known as Jim Crow laws. And so Jim Crow laws are basically embedding discrimination into law. Jim Crow laws are where that it's legal to discriminate. You can have separate schools, you can have separate public accommodations, you can say that African Americans cannot come in this restaurant or hotel. Those are all examples of the Jim Crow laws. And those come about as a result of the failures of Reconstruction, because both in the South and in the northern states, there is a move to legalize discriminatory treatment. Following the failure of Reconstruction, and you'll read about this in the textbook, there was the passage of the first Civil Rights Act of 1875. And the Civil Rights Act of 1875 was a law that was attempted to protect Blacks from discrimination in public accommodations. So sort of similar to the civil rights law that we have today, the Civil Rights Law of 1964. This basically said that discriminatory treatment in hotels, theaters, and other public accommodations was illegal in the United States. That law, federal law, went to the Supreme Court, and it was deemed unconstitutional. It was deemed unconstitutional because the court said that the 14th Amendment did not apply to the actions of private businesses. It only applied to the actions of public officials. And so an attempt to rectify and to create equal treatment under federal law failed in 1875. And then another key moment in the struggle for racial equality in the late 19th and early 20th century is the Supreme Court case Plessy versus Ferguson. You'll read more about that in the textbook, but Plessy versus Ferguson is about legalized discrimination on train cars in Louisiana. And the question comes before the court about whether or not having a black train car, a train car for black folks, and a train car for white folks, whether or not that violates the 14th Amendment. And as we all know, the answer to that is no, it does not. That the 14th Amendment tells us, at least in the way it was interpreted in Plessy versus Ferguson, that as long as the separate cars are equal in accommodations, then that is constitutional. So Plessy versus Ferguson establishes the separate but equal doctrine that underpins the Jim Crow laws. Now, as I mentioned before, the struggle for racial equality was just one aspect of the civil rights struggles of the 19th and early 20th century. The struggle for gender equality was also an important struggle as it relates to equality. Now, keep in mind that that much like race, where black folks and white folks were seen as being not equal due to their skin color, a similar approach was taken on gender equality. And women and men were seen as sort of belonging in separate spheres. And this thinking about women and men being in separate spheres was really the viewpoint that dominated well into the middle of the 20th century. There was this idea that women were needed to be protected, that they were the fairer sex, that they were also the more moral sex, right? That they were purer in many ways. And so there was a general assumption that women needed to be protected from the dirty world of public life. And that the role of law was to provide this protection from women from being involved in politics or any other sort of civil activities. There was also a sense that once a woman got married, that she lost her legal rights. They were called a woman's legal disabilities. So once a woman married, all of her legal rights were transferred to her husband. And that was seen as a reflection of this sort of separate spheres, that women maybe didn't have the expertise or the intelligence to be able to deal with legal matters. And so those legal issues were transferred to their husband. So women couldn't own property, married women couldn't own property. If they did work, they would have to give their paycheck to their husband. And if they did have a divorce, the children's custody went to men under this sort of separate spheres understanding. This was challenged in the late 19th century and the early 20th century. It was challenged quite early on in 1848. That we have the Seneca Falls Convention, which was a convention of early women's rights activists, and men were involved in that as well, including Frederick Douglass, who basically came together and said, much like the Declaration of Independence, where we assume that all men are created equal and they're endowed by these certain unalienable rights. That's what happened in Seneca Falls. They created the Declaration of Sentiments, and that basically said that women had these rights as well. So the fight for gender equality has a long tradition in the United States. One of the things in the Declaration of Sentiments that came out of the Seneca Falls Convention was a demand for the right for women to vote, which I'll tell you was not very popular at that time. So women fought for quite some time to get the right to vote, to get full citizenship rights, at least in terms of political equality, during the late part of the 19th and early part of the 20th century. A case was brought to the Supreme Court in 1875. Virginia Minor, in the case of Minor versus Happersett. Virginia Meyer, she was a leader in the women's suffrage movement. She lived in Missouri. It was illegal for women to vote in Missouri. So she went and she voted anyways, and she was arrested. And she challenged Missouri's laws, saying that that women are citizens and citizens have the right to vote. And the court disagreed with that assertion. They said that just because you're a citizen doesn't mean that you have a right to vote, that the right to vote is granted to you by your state or other laws, but there isn't a fundamental right to vote that's granted to women in the United States. So women took another tact and they said, okay, if the Constitution doesn't protect our right to vote, then we have to pass an amendment to the United States Constitution. And that was the 19th Amendment. It was introduced in the late part of the 19th century and it was finally adopted, ratified in 1920. That said that you can't discriminate against voting on the basis of sex. Okay, so that gives us a summary of the 19th and early part of the 20th century. What about the mid part of from the early part of the 20th century to the mid part of the 20th century? Well, these photos show you some of the direct action and political movements that were taking place in the 1950s and the 1960s. On the left-hand side here, you see John Lewis, who recently died, who marched over the Edmund Pettus Bridge in Selma, Alabama. It was known as Bloody Sunday because those folks were marching for equality when it comes to voting. Because even though the 15th Amendment was passed in 1870, there were lots of barriers that you'll read about and I think we know about to actually full voting rights. And so people took to the streets, marched, and were beaten in the name of seeking voting equality. On the upper right-hand side, that is a photo from the early 1960s, 1963, and that's from Jackson, Mississippi. Another direct action that people took was challenging Jim Crow laws, where that's a famous Woolworth counter photograph where African Americans, and you see that there was a white ally that was with them, they would go and they would order lunch at the Woolworth lunch counters, and they were denied service. But they would sit there peacefully, nonviolently, drawing attention to these discriminatory laws. And you see what they had to put up with. People were pouring sugar on their heads and ketchup on their heads, basically mocking their demands for racial justice. On the bottom, you see a fight for equality that revolves around gender. In the 1960s and the 70s, there was a second wave of feminism that fought for women's equality as it relates to equality in employment and in education. The National Organization of Women now was formed to fight for those rights. And on the other side is a photo from the protests that took place after the police attacks of a gay bar called the Stonewall Inn in Greenwich Village in New York City. Police would oftentimes raid gay bars and shut them down. And there was a huge riot after that and a huge street protest. And as it says there, that Stonewall means fight back, smash gay oppression. So those are some examples of the direct actions that took place demanding racial and gender and sexual orientation equality. So how did these demands on the street play themselves out in the courtroom and in law? Well, following World War II, obviously there was continued struggles for racial and gender equality. The first move on that was the legal demise of the Jim Crow laws, and that took place in a couple of ways. One way was the legal segregation of Black and white students in education, and in the landmark case Brown versus the Board of Education, that challenges the segregation laws regarding public education in the state of Kansas and in other states as well. That question comes to the Supreme Court. Is separate actually equal? And in 1954, the Supreme Court overturns the decision in Plessy versus Ferguson, bringing to an end, at least legally, the separate but equal doctrine in education. But you will read in your textbook that just because the court ruled in that way does not mean that schools were desegregated. That it took Eisenhower mobilizing the federal troops in order to escort students to school in Little Rock, Arkansas. I mean, that's the kind of effort it took to follow through on the judicial mandate that was put forth in Brown versus the Board of Education. Another demise of the Jim Crow laws was the passage of the Civil Rights Act of 1964 that was signed into law by Lyndon B. Johnson soon after the assassination of John F. Kennedy. The Civil Rights Act of 1964 is landmark civil rights legislation. It does many things. It makes segregation on the grounds of race, religion, national origin in places of a public accommodation, hotels, theaters, restaurants. It makes that illegal. It also makes it illegal to discriminate on the basis of race, religion, national origin, and gender in employment. So now you can no longer not hire somebody because of the color of their skin or because of their gender. The Civil Rights Act is followed by two additional federal laws that continue to expand racial and gender equality. We have the Housing Rights Act of 1968 that says that you can't discriminate on the basis of race when it comes to housing and mortgages. We have Title IX, which is an expansion of both the Civil Rights Act and the Education Acts in the United States that says that you cannot discriminate on the basis of sex when it comes to education. So in other words, a woman couldn't be denied admissions to a law school or a medical school because she is in fact a woman. And then when it comes to challenging discriminatory voting laws, the Voting Rights Act of 1965 is passed that prohibits literacy tests and poll taxes and other kinds of methods that discriminate against people as they vote based on their race. And then we have the passage of the 24th Amendment that prohibits the use of poll taxes. And so those are an overview of the major civil rights legislation from the mid part of the 20th century. So where are we today in terms of the fight for civil rights? Here are just some pictures from the early part of the 21st century that gives us an idea of what people are continuing to fight for. In the upper left-hand corner is a picture from Milwaukee and the marches that took place this summer. I think that photo is from the march in Bayview. A protest that took place in response to the killing of George Floyd. So the Black Lives Matter movement demanding racial justice as it relates to policing in the United States is a good example of the continued struggle for civil rights. On the upper right-hand corner is a picture of the Me Too movement. And so in the early part of the 21st century, there was a reporting that was done by the New Yorker magazine and the New York Times that reported the prevalence of sexual harassment and sexual assault within corporate America. You're probably familiar with Harvey Weinstein, who is a movie producer, and the vast quantities of sexual assault and harassment that he engaged in. So the Me Too movement is sort of this this awakening moment where we think that we've made a lot of progress when it comes to sexual assault and sexual harassment, which we have done in the 20th century. But there's still a lot of work to do, and that's what the Me Too movement brings to light. On the bottom, we see on the bottom right hand is a picture of Dreamers. Dreamers are people who were brought to the United States by their parents, who are basically, they were brought here as children, and so they're basically here undocumented and illegally. But there's been a move, it's called DACA, that stands for Deferred Action for Child Arrivals. Basically saying that if you came to the United States as a child, that you should not be removed from the United States, that you should begin to have a pathway towards citizenship. And on the other side is the fight for marriage equality, okay? And so all of these, that is marriage equality for gay and lesbian folks in the United States. So all of these are examples of the continued struggle for civil rights in the 21st century. So what have been some of the legal, either through the courts or through legislation, movements on civil rights as in the 21st century. Well, just this summer, there was a landmark case that was heard by the Supreme Court, and the name of the case is Bostock versus Clayton County, Georgia, and it was decided in 2020. And the question that was before the court in this case was whether or not Title VII of the Civil Rights Act applies to sexual orientation and gender identity. Now, the Title VII of the Civil Rights Act says that you cannot discriminate in employment as it relates to sex. So it prohibits sex discrimination. Well, does that mean that it also prohibits discrimination against people who are gay, lesbian, or transgender? And in a landmark ruling written by conservative justice, the majority opinion was written by the conservative justice Neil Gorsuch, they concluded that Title VII does include sexual orientation and gender identity. And so when it comes to equality in the United States, people who are gay, lesbian, or transgender can no longer be fired because they are gay, lesbian, or transgender. And so that's a real move towards expanding equality in the United States. We also have the Supreme Court decision, Obergefell v. Hodges from 2015, that says that you have a constitutional right to get married if you're gay or lesbian, and so solidifying marriage equality for all people in the United States. We have the executive order that was passed during the Obama administration, but that has been challenged by the Trump administration. But the challenge to DACA, Deferred Action for Childhood Arrivals, was found to be unconstitutional this summer as well. And so the Trump administration wants to get rid of DACA and says that just because you arrived to the United States as a child doesn't mean that you should not be subject to deportation. And the Supreme Court said that the overturning of DACA or the lack of enforcement by DACA by the Trump administration was unconstitutional. And, finally, the Black Lives Matter movement, or not finally, but the Black Lives Matter movement is about police accountability and getting rid of the qualified immunity that law enforcement have. A qualified immunity is basically saying that police are not subject to being sued when they violate a person's civil rights. And so that's been, we'll see where that goes in terms of legal and court decisions regarding that further expansion of racial equality. So in conclusion, I want you to think about civil rights as an intersection of social movements, changing attitudes within our society, court rulings, and federal and state laws. That to expand our understanding of equality in the United States, it takes all of those things. It takes people fighting on the ground, demanding equal treatment. It takes a changing attitude within society to accept equal treatment for people that are different than us. But it also takes people electing presidents, lawmakers, and then ultimately, in an indirect way, nominating Supreme Court justices, because if you elect a president, they're going to nominate justices that are going to fight or not fight for an expansion of civil rights. And so, the struggle for civil rights is really about democracy. It's about government of, for, and by the people, and that the people can protest, bring attention to injustice, and hopefully make changes, either through court decisions or through laws. All right, thanks for your attention, and I will talk to you again soon.